Thanks very much, Kate, and to all at the Bonavero Institute. It's a real pleasure to be able to speak to you, even though I'm disappointed not to be able to come to Oxford as originally planned. But I'm looking forward to the discussion today and to being able to engage with you on this topic, which is a topic which is very close to my heart. So I'd like to start by talking about why freedom of thought. We're very used to hearing people talking about privacy and data protection in relation to technology. But in my view, while privacy is clearly absolutely key, privacy is a gateway right, but privacy is only the beginning, and the same goes for data protection. So how I first came to think about freedom of thought was when I first read about Cambridge Analytica and political behavioral micro-targeting in late 2016. And when I first read about this idea that Cambridge Analytica had developed a product or a service which allowed it to understand how Facebook users on an individual level thought and felt, and to use that information to provide personalized targeting of political messaging, it felt to me that this wasn't just a question of privacy, but that the reason why this was so disturbing, because it was absolutely to do with autonomy and the right to freedom of thought. Our ability both to think for ourselves, to make our own ideas and have our own opinions, but also our ability to keep how we're feeling private. And so when I started looking into the right to freedom of thought, I was quite surprised to find that it, over the 20th century, had become more or less a forgotten right. And one of the reasons for that, you can see in some of the case law or the academic commentary, is that while freedom of thought has always been recognized as fundamental to humanity and the right to freedom of thought as a crucial plank in human rights protections, there's been an assumption that, of course, no one and no government can actually get inside our minds. And so while it was de facto a highly protected right, there was no need to do anything extra to protect it. But the Cambridge Analytica story for me was just the beginning of a revelation of why in the 21st century that's no longer true, and why we need to start thinking more carefully about the right to freedom of thought, what it means, and how we can protect it. One of the things that I think is really important when thinking about freedom of thought is that while it's both an ethical and a philosophical concept, and something that has become current in philosophical thinking, particularly since the Enlightenment, it is, at least since the drafting and approval of the Universal Declaration on Human Rights, also and crucially a legal concept. So looking at the legal framework, what does international human rights law do to protect our right to freedom of thought? Well, freedom of thought has both an internal and an external aspect. And the right to freedom of thought is found alongside the right to freedom of religion and belief in international human rights law in Article 18 of the UDHR, and in related rights in the ICCPR, the European Convention on Human Rights, the EU Charter, and other regional human rights institutes, human rights instruments. But as well as freedom of thought, you also find the right to freedom of opinion connected to the right to freedom of expression and the right to freedom of information in Article 19 of the UDHR and related instruments. And so while those protections are contained in separate rights, the right to freedom of opinion can be understood as well within the concept of the right to freedom of thought. And so those two rights are very much interconnected. But what both freedom of thought and freedom of opinion have in common is that they have both an internal and an external aspect to the right. So we have a right to think whatever we like and to form whatever opinions we like inside our heads. And that is what is known as the internal aspect of the right. And that internal aspect of the right is an absolute right. The second part of the right is an external aspect of the right. And that is the right to express my opinions, to express and manifest my religion or my beliefs And those external aspects of the rights can be limited in certain circumstances. So it's important to make a distinction between the rights as they apply to what's going on in my inner space and the rights in terms of my ability to express or manifest what I'm thinking, believing, or the opinions that I have. The scope of the rights is also crucial, because the right to freedom of thought and the right to freedom of opinion do not rely entirely, or do not only apply to thoughts that are of a weighty matter. So the Human Rights Committee, in its general comment 22, found that the right to freedom of thought, conscience, and religion, including the freedom to hold beliefs, is far-reaching and profound. It encompasses freedom of thought on all matters, personal conviction, and the commitment to religion or belief. I think it's also important in thinking about thought to understand that this far-reaching and profound right effectively relates to what Martin Scheinin has called the absolute character of the freedom of an inner state of mind. So it relates not only to ideas, philosophical thoughts, political opinions, but it also relates to things like my emotional state, my feelings, my daydreams, if you like. And so freedom of thought really covers everything that is going on in our inner space. As I mentioned, when you're talking about the internal aspect of the right to freedom of thought, one of the reasons why freedom of thought is such a useful and strong idea in terms of understanding our relationship with technology and the limitations of our relationship with technology is that freedom of thought is an absolute right. That means it can never be derogated from, and there can never be a justification for an interference with the right to freedom of thought. So whereas with the right to private life, there can be justifications for limiting the right to private life, for example, to protect health or to protect national security. When it comes to the right to freedom of thought, as long as those thoughts and those feelings and ideas remain inside my head, you can never have a justification for limiting or interfering with that right. And that is a really strong protection in international law. And the right to freedom of thought and the related forum internum right to freedom of opinion are one of only 3 rights in international human rights law that are protected in this absolute way. The others being the right to freedom from torture, inhuman, degrading treatment and punishment, and also the prohibition on slavery. And I think if you think about those 3 rights together, you can get an idea of why they're so fundamental to our humanity. They're absolutely questions about humanity, dignity, and autonomy. And all those 3 rights are absolutely protected. But what does it mean in practice to protect the right to freedom of thought? Well, it's not just about brainwashing or manipulating people's thoughts. There are 3 key planks to protecting the right to freedom of thought in international law. The first part is the ability to keep our thoughts private. That means that while I am daydreaming, thinking inside my head, you can never have a justification for trying to force me to let you know what I'm thinking. So there's an absolute prohibition on trying to get inside somebody else's head, to try to read people's minds. And privacy, obviously, in that aspect is, as I say, a kind of gatekeeper right. You can't have freedom of thought without privacy. The second plank is the freedom from manipulation and the freedom from undue influence on our thoughts. And the third plank is the freedom from punishment for our thoughts. And that relates to the first one. Once you try to understand or extract my thoughts from my head, then there is a possibility that down the line, one will be punished for those thoughts. The right to freedom of thought in international law in relation to states puts both positive and negative obligations on the state. So what that means is that states are obliged to refrain from trying to interfere with our right to freedom of thought. So states should not be doing activities which seek to get inside our heads in any way. But also they have a positive obligation to protect us from others, whether that is to protect us from each other or to protect us from businesses and business practices. And those positive obligations mean that states have to draw up adequate regulatory and legal frameworks to protect our right to freedom of thought. And they also have to make those frameworks practical and enforceable. But so far, while the right to freedom of thought in international law has this very, very strong, strongly protected status, it's barely being used either in the courts or very little in academic literature. But as Kate said at the start, that is slowly starting to change as we're starting to realize that in the 21st century, with the development of technology and artificial intelligence, increasingly the space inside our mind is becoming a contested space and one that needs to be protected. So where are the kind of areas that you might see interferences with our right to freedom of thought? Well, when I started looking at this from the point of view of being concerned about Cambridge Analytica and the political sphere, the more I looked into it, the more I realized that everywhere I looked, there were examples of technology or practices that were seeking to either understand how we think or change how we think and behave, or potentially to make decisions based on inferences about how we may be thinking or feeling. And it's across so many sectors that it's difficult really to limit where you should be looking in terms of protecting freedom of thought. But just to give a few examples, and I think these examples show how the right to freedom of thought is so important and how interferences with the right to freedom of thought potentially affect all of us and all our societies. So looking first at social media, the ideas behind behavioral micro-targeting have arisen from research done around social media. And that research, to give a couple of examples, in 2012, Facebook published some research on the way social media news feeds could affect and potentially manipulate people's moods. So by selecting a random sample of Facebook users, their news feeds were curated so that some people got uplifting, positive messages in the news feed, while others got much more negative news feeds. And at the end of the research period, the researchers found that those who were getting persistently negative news feeds were increasingly demonstrating negative feelings and emotions in their own activities and postings on Facebook. So this research was evidence that the way you receive the information that you're getting through your newsfeed, whether it's Facebook or any other newsfeed, has an impact on and can change your inner state, how you're feeling, and how you then potentially go on to behave or express yourself. A second bit of research that is crucial in the behavioral micro-targeting model was the research on interpreting personalities through likes. And you may well have seen about 5 years ago, there was a series of reports about how Facebook knows you better than you know yourself, or better than your family might know you. And that research showed that by interpreting the things that you like on Facebook or the things that you engage with on Facebook, that they could demonstrate a sort of psychological profile about you. Those pieces of research fit in with a general trend in artificial intelligence and in technological research for understanding how our micro-expressions and the way that we use technology, the way that we look at things online, can be used to interpret who we are, how we feel, what we're thinking, in ways that potentially go beyond what we realize that we are revealing. So the research on likes, for example, is not about understanding what I think about a particular politician because I've written something about that politician on Facebook or liked that politician on Facebook. What the research on likes is saying is more about interpreting how I may feel about a particular political campaign or a particular issue based on random or seemingly random ways that I have interacted online, which may include me liking a cat video and liking a particular type of music. But all of the information that's being gathered about me on a constant basis is being used to build a picture of my inner state. And in 2017, there was reports, or there were reports in Australia that Facebook was offering advertising services that claimed to be able to target teenagers and young people based on real-time interpretations of their emotional states, which would allow advertisers to benefit from moments when teenagers were potentially feeling vulnerable or insecure. And while Facebook, in response to those articles and those leaked documents, said that they were not selling those specific services and were not targeting teenagers in that way, this idea that we can be followed through our online activities in a way that gives a real-time picture of how we're feeling and how we might be targeted, whether it's through political messaging or through advertising, is something that is becoming increasingly common and increasingly a part of our everyday engagements online. And in my view, this idea that we are being constantly interpreted, our emotions and our psychological states being constantly monitored, is potentially an interference with our right to freedom of thought, which governments are not yet sufficiently addressing and protecting. In the sphere of politics, and as I say, I started out thinking about freedom of thought from the perspective of Cambridge Analytica and behavioural micro-targeting. But the business of neuropolitics, what's known as neuropolitics, is something that is also increasingly developing in the political sphere. Studies around neuropolitics have shown that people can be identified with a fairly high degree of accuracy as either Democrats or Republicans based on brain scans taken during activity not related to politics. So researchers from the University of Exeter, carried out research on people's responses and the shapes of their brains, their brain activity in response to risk-taking activity, so a sort of gambling game, if you like. So not a game and not an activity involving political questions. But what they then found when they looked back at those brain scans was that they could predict with about an 80% accuracy, looking at both the shape of the brain and the way the brain activity operated around this activity, whether or not the subjects of the research were Democrats or Republicans when they checked that against their political affiliations in the public domain. So the idea that through neuroscience you can start literally to look at somebody's brain and understand which way they are likely to vote poses really serious questions for our democratic systems and our democratic society in general. And while the example of that experiment is particularly acute, there are increasingly neuroconsultants or neuropolitics consultancies offering their services globally and being used by political campaigns globally to understand how voters are feeling, how voters are responding to their messages, and also potentially to understand how voters are likely to vote, even potentially before they've decided themselves. And I think that question around neuropolitics, as much as the questions around behavioural micro-targeting in politics, raise very serious questions for the protection of democracy. And that if we want to continue with democratic societies, we need to start thinking about how we can protect the right to freedom of thought in our electoral systems. Another area that I think it's important to note is in the education sector. And increasingly in many countries, surveillance mechanisms are being used to interpret the moods and emotions of children, whether that's in the name of safeguarding or of preventing radicalization and identifying problems early on. But these systems are being used to monitor our children and understand how they're thinking and feeling in a way which may well amount to an interference with their right to freedom of thought. And when you take that to the extreme, you can look at an experiment that was being carried out in China using headsets that indicate to the teacher whether or not children are paying attention in class. And that is a sort of direct reading of their brain activity to understand whether or not they are paying adequate attention. In the criminal justice system as well, increasingly both big data and facial recognition technologies are being developed, rolled out and billed as the next great thing in preventing crime by identifying risks of criminality and inferences about people's states of mind. And in the criminal justice system, I think it's extremely important to bear in mind that prohibition on being punished for your thoughts. And there's a real risk that these kind of technologies, whether or not they can be relied on in any event, are ways of trying to understand thoughts and to criminalize thoughts instead of behaviors. So what do we need to do to protect the forum internum, to protect our right to freedom of thought in this new and fast developing technological space? Well, one thing that I think is really important is for the law to define the line around the forum internum. So while, as I've said, the scope of the right to freedom of thought is very wide and covers all kinds of thoughts and emotions that go on in our inner space, what's not quite so clear in legal terms is where exactly the line is around that inner space. At what point do my thoughts leave my head and become expressions, in which case their protection may be limited for various reasons? Are my micro-expressions that might be being read through facial recognition technology or through analysis of my writing or my social media feeds, are those expressions or are those inferences being taken about my forum internum without me expressing them? And I think we need to really find out exactly where that line is. What am I expressing and what am I keeping to myself? I think as well, we need to start developing clear domestic and international laws on specific areas. And those laws need to be clear about what is permissible, not just about what is possible. And they also need to incorporate the precautionary principle, the idea that technological developments should not be allowed where they're going to create really serious moral and societal harms or have the potential to do that. So just because you can do something or could do something doesn't mean you should be allowed to do it. And one of the things I found very interesting about the debates around Cambridge Analytica was that on the legal side, the discussions seemed to be around whether or not there had been a data breach of Facebook, or whether or not there had been a breach of electoral standing laws, for example, in relation to the referendum in the UK. But for me, those issues are really peripheral. The fundamental question is, should any organisation or political campaign be allowed to use our data in order to draw inferences about our inner lives, our emotions, our thoughts, our political opinions, and then to be allowed to use targeted advertising and dark advertising in order to manipulate and influence the way we behave and the way we think as a result of that? And in my view, the answer to that is no. But what I found very interesting in the UK is that when the Data Protection Act was brought in at the height of inquiries around Cambridge Analytica and front page news spreads about the Cambridge Analytica scandal, at the same time, political parties and politicians of all shades passed the Data Protection Act in the UK, which allows political parties to collect data about our political opinions and use that in ways which no other data controllers are able to use our data. So it allows pretty much business as usual for political parties to collect and use data, very sensitive data, inferring our political opinions and our thoughts. Interestingly, around the same time in Spain, the Spanish Parliament passed similar legislation. But in Spain, the oversight body, the Defensor del Pueblo, raised concerns about the compatibility of the law with the Spanish Constitution, both with the right to private life, but really importantly, with the right to ideological freedom in the Spanish Constitution. And the way that that complaint was brought to the Constitutional Court really made it very clear that the right to private life and data protection was very much a gateway right to this fundamental idea of the right to ideological freedom. The Constitutional Court ruled on the case in record time. I think it was within 2 months. They came to the conclusion that these provisions in the Spanish law were not constitutional. Their judgment primarily rested on the right to private life, but also recognized these arguments around ideological freedom. And so I think it's very interesting to see how in Spain, while politicians like British politicians were very keen to have access to the political opinions of voters and information and inferences about political opinions of voters, the Constitutional Court and the constitutional mechanisms allowed for that law to be struck down quite quickly. While in the UK, so far, there has not been a direct challenge in the courts of the Data Protection Act exemption for political parties. But it's not just about law and constraining government and politics. I think it's also very important for business to build freedom of thought into its business models. Because the way that technology has developed in the past 10 or 20 years has been very much driven by this idea that we can understand and influence people on an individual and on a societal level through technology, understanding how we work, how we think, how we feel. But without freedom of thought, future developments in science and technology are going to be stifled. And I think one thing it's worth bearing in mind when thinking about the right to freedom of thought is that when it got such universal support through the drafting process of the Universal Declaration of Human Rights, right across the political spectrum, the Soviet Union, for example, supported the idea of the right to freedom of thought, not as something connected to religious belief, but rather as something that's absolutely necessary for effective scientific and technological development. And I think for business and technology companies, identifying this kernel around the right to freedom of thought, this line around the right to freedom of thought that just can't be touched and must be protected, will launch a whole new phase of innovation, which could take us down a new path, which leaves our right to freedom of thought protected in the future. I'll stop there and hand over to Kate. I think I've come to the end of my half hour.
Thanks very much indeed. That was really interesting. Kate Jones, are you available and can you turn on your camera and speak to us?
I can. Hello everyone, and thank you Susie for an absolutely excellent presentation on freedom of thought, which really has helped, I think, to illustrate and elucidate this most difficult of rights to understand. As Susie said at the beginning, it's absolutely vital that the right to freedom of thought should now be better understood. And expositions like hers are a really good starting point in doing this. I have found people saying to me, well, this isn't really something we need to focus on, is it? Because we have freedom of expression and privacy rights which are well understood, where the parameters are clear. But for the reasons that Susie's just given, it isn't enough to focus only on expression and privacy. We need to be thinking about the rights to freedom of thought and freedom of opinion themselves. there wasn't such a need for this before, as Susie has explained, because the possibilities didn't exist in the same way for manipulative interference with that forum internum in the way that they now do. And I think it's vital that we as human rights lawyers turn our attention to this more. Susie gave some excellent examples of the sort of challenges that we need to be thinking about here, including psychological profiling, including the application of neuroscience in politics in terms of affecting how people may vote, and then other examples such as measuring attention spans of children in class and whether children are actually paying attention, and using facial recognition technology to determine the risk of criminality. All of these ideas are very different to what we're used to thinking of as normal in our world, and they are all concepts which are coming to fruition with the advent of technology. So, as Susie said, in the past, we were subject to attempts to influence our thoughts. Of course we were, all the time. On the whole, we entrust the state with educating our children, and we know that of course will have a big influence in how they think. We're all subject to advertising all of the time. We buy our daily, or in the past we buy our daily newspaper knowing that it would be propounding a particular political point of view, and so on. So attempts to influence your thoughts have always been there. And that's not what the problem is. But the question is, as Susie said, where do you draw the line between those normal and legitimate influences on thought and opinion on the one hand, and then inappropriate ones on the other? Because I think that many people would agree that some of the examples that Susie was giving were interferences with our thoughts that we would not feel comfortable with. And yet now there's the potential for these on a large scale. It's sort of 1984 science fiction style ways. So the possibilities for manipulation are growing rapidly with development of the neuro industry and the technology to scale that to the masses quickly and cheaply. As regards social media, just thinking about one particular area, to some extent the potential for manipulation is baked into the design of social media platforms, given that the commercial reasons or the commercial way in which platforms operate are about tracking the individuals who use them, profiling individuals who use them, and then targeting with advertising. That, of course, is the commercial model. And I'm not suggesting that that is illegitimate, but that gives potential for the kinds of interferences that Susie has been talking about. On the political side, studies have shown that political bias isn't rational, therefore that it can be open to exploitation. And we see, for example, on social media, the greater impact of the negativity bias, that negative stories will garner more attention, that stories that provoke an arousal response, such as anger or disgust, will also provoke more attention, or that stories that are divisive and divisive messages will also perhaps provoke more attention, for example. So then, again, the question is where you draw a line between what is legitimate and what may become illegitimate in that area too. And in all of this, at the moment, we don't see a regulation by governments, and we don't see platforms, social media platforms or others, addressing the kind of issues that Susie has been talking about. We see, as Susie has discussed, commercial companies beginning to offer these services, whether to political actors or to others, and perhaps offering them for, in principle, benign, what may appear to be benign reasons, such as tracking children's attention spans or perhaps monitoring for the prevent agenda in schools, but without thought as to the human rights implications of these, particularly as regards surveillance and then potential impact of these. As regards platforms, we know, for example, that Facebook looks for examples of coordinated inauthentic behavior in order to take them down, but that this coordinated or inauthentic behavior is focused on the who actors who may be misleading people. And we also know that the platforms are looking for certain forms of expression that need to be taken down for violation of laws on hate speech and so on. But we don't see the platforms looking for these kind of techniques because it's not yet sufficiently in the public consciousness that they do so. And Facebook itself, for example, say that they perceive gaps in regulation as to what extent, say, targeting in political acts should be lawful, as to whether astroturfing, that is giving the appearance of mass support for something through fake accounts, through likes and so on, is legitimate. So if even these questions are undecided for platforms, then we're really not even at first base in considering these questions about potentially illegitimate manipulation of people's thoughts. So I think the big question for human rights lawyers is the one that Susie has been asking. Where do we draw the line around the forum internum? Or as Google put it, where is the creepy line? We see terms being used like illegitimate influence or manipulative interference. What's the difference between what's acceptable and what's not acceptable? Where do you draw the line between appropriate advertising and inappropriate manipulation? It may be that one aspect to focus on is awareness. So if, for example, I am influenced by an advert because the social media platform I watch keeps showing it to me, at least I know that I've seen it several times and that perhaps this third time or this fourth time I might actually click on it. But if there is something darker going on, perhaps some more reading of my face and my reactions to what's happening, and then tailoring ads towards me accordingly, does that cross over the line because it's done without my knowing about it? So how do we draw this line? And it may be that knowledge is one aspect of that. And when we start thinking about the right to freedom of thought, it seems to me that some of the problems we've been grappling with, perhaps on the freedom of expression side or the privacy side, they get focused in a way that may add clarity to them as well. So for example, we know that there's a debate about deep fakes. If you think about deep fakes from the perspective of the right to freedom of thought, and then perhaps of awareness about what's happening, then perhaps it helps us to assess the legitimacy of deep fakes in a way that hasn't really been possible while thinking about them through an expression lens. So Susie gave a few ideas of what to do about this, and this is also where I would like to pick up and perhaps is a good starting point for discussion. But it seems to me that the very first thing we need is transparency, because this field is growing, this field of neuroscience brought to many people, and this field of neuropolitics, to take the political example. But most of us don't know about this. So transparency, for example, in what political parties and political campaigners and those following them are doing, seems to be an absolutely vital first step. Transparency as to what's being done with data taken from our facial expressions as we speak, for example. Secondly, even having government seized of these issues seems to me something that we haven't yet got to and needs to happen. So for example, in the UK, we have the Department for Culture, Media and Sport, which is of course working on an online harms bill. But is that really the department to be thinking fully about these issues? Do they really fall within culture, media and sport? Or if not, which part of government should the lead lie with? And so which part of government is likely to be even actively monitoring these issues, let alone then, of course, applying a human rights lens to them from the perspective of the right to freedom of thought and freedom of opinion. Thirdly, I think we need to be really honest about where the boundaries of legitimacy are, and to make sure that those debates are driven by human rights law and ethics and so on, and not so much, or not by commercial considerations. I think there is a risk that regulation is always paying catch up to commercial structures. I think we see this to a certain extent with social media platforms, for example. And if considering the right to freedom of thought and freedom of opinion means that there needs to be some kind of structural change to, for example, social media platforms, then I don't think we should shy away from that. There may be significant impacts on structures that ought to be had. It is easy, I think, for us to be diverted back onto the expression issues, to think, well, what do we do about disinformation and so on? And the privacy issues too, which of course are really important. What do we do about micro-targeting within the structures we have? But in my view, we should also be considering those technical structures themselves. And if they're not compatible with the right to independent thought, then we should be thinking about whether changes are made. And of course, it's not fair to expect any commercial entity to be entirely self-regulating in this area, just as in any other area too. I do have questions I could ask of Susie, but I'm sure that other people listening in will do as well after her excellent presentation. So I think I will stop it there and look forward to more of the debate. Thank you.
Well, thank you very much indeed, Kate, and thanks also to Susie. And we have a range of interesting questions that have come in, and I'm just going to put them to you, and please do ask if you want me to repeat them. So, Susie, the first question that came in was for you, and it is, what are your thoughts regarding organizations or companies having founding principles and consequently claiming for themselves a company's freedom of thought or freedom of religion or freedom of expression? And the example that the questioner puts is the case, the Hobby Lobby case in the United States Supreme Court, or the Little Sisters of the Poor case, where companies asserted religious rights in relation to the treatment and manner in which they were going to treat their employees in Hobby Lobby anyway. What are your thoughts on how that fits in with your understanding of freedom of thought?
I think that's sort of a separate issue. So I think that comes into the external aspect, if you like, of religion and belief and thought. So it's about the manifestation of religion, thought and belief, which can be limited for various reasons in the same way that privacy or expression can. And so then you get into potentially questions about balancing rights against each other. But I suppose what I'm talking about is more that internal forum internum protection, which is the absolute protection. And I don't see how that can apply to a company's founding or foundational principles, because those are by definition out there and expressed, rather than being simply an internal question of the mind. So I suppose what I'm talking about is very much that definition of absolute protection of what's going on when I'm not expressing my inner state.
Yeah, and so, and your suggestion would be that forum internum actually requires a sort of a human mind that is reflecting on something, rather than a corporate legal structure, which is in some ways an artificial structure.
Yes, and I think, I mean, a corporate legal structure is set down and expressed, if you like. I think it's very much, you know, the idea of the forum internum is about that very human idea, and it comes down to, I suppose, religious ideas of the soul and the mind versus the brain, which I don't think you can apply in the same way to a corporate structure.
Yeah. So, and the next question then refers to one of Facebook's quite widely publicized practices of using AI to monitor for people who are expressing suicidal risk and ideas, and their published proposal to try and provide people with access to mental health advice, potentially contact friends or family if they think it's severe. I mean, this clearly is close to the area of freedom of thought. What are your thoughts on that?
Well, I don't know enough about the detail to sort of do the legal analysis of it, but you know, in general, applying the principles, I think, you know, if somebody posts on Facebook that they're considering killing themselves, you're in the same kind of situation as you are with many businesses, where if you're talking to somebody on the phone and they express suicidal thoughts, then you have a sort of obligation to protect life. But that's quite different from just inferring from somebody's general activities that your AI has decided that maybe they have suicidal thoughts. And I think that that is a very difficult line. And as I say, I mean, in principle, you know, the right to freedom of thought is absolute. And therefore, if I'm not telling you or expressing something, then you don't have the right for any reason to try to go inside my head. And I think that that is also quite different from a sort of interpersonal exchange, which you might have, for example, in an academic setting, you know, engaging with students. If you pick up that a student is suffering in some way, then you know you have a way of engaging with them, which is not the same as just running data through a computer to try to understand what's going on inside their head and then flagging that to the police. So I would be quite concerned about the details of how that works, although obviously the goal of preventing suicide and protecting life, you know, is a laudable goal. But I think that's why it's important to understand where that line is about what I'm expressing and what actually I'm keeping inside my head. And I think there are, as I understand, there are many people who have fleeting suicidal thoughts, or who may have suicidal thoughts, who are never in a position where they're going to act on it, and other people who obviously are in great danger. And I feel a bit uncomfortable about the idea of a platform making that judgment call. And as I say, I think there is a big difference between somebody expressing those thoughts through Facebook and those thoughts being inferred through the way they're using Facebook. And I think that is the question of where is that line exactly.
Yeah, and it seems to me from what you say that there really are two lines. So the first line is the line between the forum internum and the external aspect, which is in some ways, when you take the Facebook example, it's about, well, is the person actually expressing suicidal thoughts on an expressive platform? Then maybe you move to expression, and maybe one thinks about that differently. So there's that line. And then there's the next line, which is raised by a questioner who asks about how we should think about rehabilitation in the criminal justice process, and a recognition that one of the aims of punishment is to rehabilitate offenders, and how that fits in with changing people's mindsets and freedom of thought. And it relates as well to the point that Kate made, which is that really a lot of education is about channeling and thought and ideas and norms and values. And is that something that we should be seeing as a breach of freedom of thought? So that's really about what are actual breaches, what types of conduct do we think are legitimate and what are not, and how do we draw those kind of lines?
Yeah, I think that is absolutely, as both you and Kate have pointed out, I think that is the other crucial line, which we don't yet have, is particularly on the influence question. What is legitimate influence and what is manipulation? You know, I mean, I'm trained as a barrister and have spent 20 years working in advocacy, which hopefully persuades people to shift their position on things, I hope in a legitimate way. So it's not to say that you can never influence other people. Clearly, you know, society is about influencing each other, exchanging ideas. It's important to be able to exchange ideas. The question is, what is illegitimate manipulation? And I think one of the areas, I suppose, potentially is about, as Kate as well said, it's about the sort of transparency question. I mean, if I turn up at a meeting to tell you what I think about something, I'm clearly there to try and persuade you of my position, and you're then in a position to understand and process it based on that. If, however, I'm just looking at my Facebook feed and seeing a blanket of misery, and not understanding that that's been curated in order to see whether I feel miserable at the end of it. I think that that's a very different perspective. Where that line is drawn, I think, is definitely one of the first issues that needs to be teased out, both in sort of academic analysis, but also in the courts. And, you know, we need to start bringing these questions to the courts to understand, okay, maybe this is okay, but that's not okay. And I mean, some of those lines as well, you know, you can have a very immediate response to them. So as we were talking about in the political example, would you really think it was okay for somebody to come and look at my brain scan and decide which way I was going to vote, to then make a decision about whether or not they want to make me feel like I want to go to the ballot box next week or not? I mean, I would say that's a fairly obvious no from a sort of legal perspective. But there are many other areas which are a lot more blurred, and as Kate raised when you're talking about education. But also, I think on advertising, I think it's very interesting that, you know, historically we've been quite happy to ban subliminal advertising, and yet somehow we haven't done anything at all about behavioural micro-targeting. And I don't understand at all, except that it seems to me that that's just a big gap rather than a deliberate decision that one is better than the other.
Kate, would you like to come in on any of these questions that I've put to Susie?
Yes, thank you, Kate. Just briefly, and really to complement what Susie has said, I think as regards the suicide question, the only point I would add is, imagine what it would be like if you were living in a world where you felt that you couldn't even think something because of a risk that the device you're sitting opposite might pick up on that, and that might spark either action by authorities or recording of the perception of your thoughts by authorities, which could be used against you in some way in the future. I think that's quite a scary world that is being conjured up by that idea. Secondly, on this question about education versus and re-education and rehabilitation versus legitimate education, I mean, there's a little bit of case law on that, but not very much. So the Human Rights Committee has dealt with a couple of individual complaints about rehabilitation centres and has not really engaged with the freedom of thought point. But the issue is there, and clearly there's a dividing line to be struck there. And in the Lautsi case, I think on the education side, the court said something about the dividing line in education, and I don't have the words to hand, but about not going so far as indoctrination without parents' consent, you know. And so you can see that there are clear examples on one side of the line or the other, but what hasn't yet been defined is the line in between the two.
Yeah. So one of the other questions that's come in talks about or focuses on your point that the forum internum is in fact an absolute right. The protection of that area of freedom of thought is absolute. And the question says, isn't formulating it like that making it perhaps more difficult for us and producing what is rather a difficult line drawing exercise between legitimate forms of activity, which we will say is not in fact kind of limitation of forum internum. So whether it's education or rehabilitation or that sort of thing. If we weren't using absolute, we could do it in some kind of proportionality balancing sense, which would include legitimate purposes and so on. And that just might be an easier way of thinking about this. And I have to say that coming from a jurisdiction where we don't really use the idea of absolute rights at all rights may be limited, although obviously some are much more difficult to limit than others. That's, you know, has an intuitive attraction for me. I don't know what you think about that, Susie.
Well, I think that slightly misses the point. I think that, you know, there's a reason why the drafters of international human rights law made the right to freedom of thought and forum internum absolute, in the same way as the prohibition on torture and the prohibition on slavery. And I mean, you know, I don't think it is a more complicated question. The question is how to define what is protected absolutely. And actually, I think that really does go to sort of crucial human questions. And that's where I think the sort of privacy question and the data protection, the way data protection law and privacy law have developed using proportionality, which is extremely important, but it becomes a kind of compliance exercise. Whereas I think when you look at absolute rights, you know, they've been set up that way. It's not really a question of a choice. That's what they are. You know, they are absolute rights protected absolutely in international law. If you start to take that away, then you've thrown away all human rights protections. You're making human rights law just a sort of optional in and out selection. So I think it's about having a core of values. And I mean, we've talked about how privacy is a gateway right, but there is that sort of core, which just means you can never have a reason for breaching that core. And I think that there are very good reasons for having that triumvirate of absolute rights, which go to the core of human autonomy and what it means to be human. And that if you start chipping away at those, you're on a slippery slope away from human values.
Another question is related to some things we've already spoken about before, but it is this balancing between freedom of thought on the one hand, the freedom that, the sense that we won't try to manipulate people's thinking, with freedom of expression and protection of political speech, which are often aimed at doing precisely that. And do we need to find some, so this is back to, I think, the line drawing between what's legitimate and what's not legitimate, and how are we going to build that, how are we going to find that balance in a way that's coherent and widely accepted?
I mean, just briefly, then I'll pass over to Kate. She's also talked about this quite a lot. My sort of sense is one of the lines is where it's about individual targeting, or the kind of engagement with the individual, which is different from political speech in a broader sense, which, like advocacy, political speech is designed to persuade people to vote for you. I mean, that's the bottom line of what it's for. But I think it's very different when it's being done in a way that is based on inferences about an individual person's emotional responses, ideas and thoughts. And then being targeted on a sort of individual or micro level. I think that is very, very different from broader political messages. And I think, as well as Kate's flagged in terms of sort of disinformation, including political disinformation, it's looking at the delivery methods rather than the content and what that does to how people think. And I think that is a question which really needs to be unpicked. And I don't have all the answers for that. But I mean, I think it's very interesting to give an example, which is not directly political, but there was some research done about at a Flat Earth conference, where the researchers found that everyone at the conference, bar one, had come to believe in Flat Earth theory, having been directed there through YouTube, where they were originally looking at other conspiracy theories. The one that hadn't come through YouTube had come through, I think, a son-in-law or daughter-in-law who had come through YouTube and then brought him along for the ride. But it was interesting that every single person the researchers spoke to had come to be committed enough to Flat Earth theory to actually, pay up and go to a conference. Whereas I don't think, those people seeing the Earth is flat on a billboard at the bus shelter would have been, would have had their minds changed in quite the same way. So I think that there are very important questions about the way technology engages with our thought processes and our minds, which is quite different from just the content of speech.
Yeah. Kate, would you like to comment on that?
Well, I very much agree with everything that Susie has said, really. So finding that dividing line between legitimate and illegitimate is really very difficult, and we're right at the beginning of it. Targeting is part of it, but of course targeting doesn't explain everything. If you think about these Flat Earth videos that Susie was just talking about, they weren't targeted at the people who then signed up for the conference. But there's something about means of distribution which is interesting, including means of distribution which are benign in themselves. For example, the fact that you're more likely to read something if it's sent to you by a friend or family member than if you just encounter it otherwise. So the question is about the impact of those. And as Susie says, about the techniques. And you can think of even quite perhaps trivial examples, you know, the fact that in Russia there are vending machines where you can go and press a button to get 200 Instagram likes, which come within a minute for your post, you know. Very small examples, but the question is, where do we draw the line between what's right and what's not right, and to what extent does honesty matter in this as well? And as I said before, I do think that the transparency and knowing what is happening to us is perhaps an element of that.
Yeah. Thank you both. I mean, another of the questions has asked how we would assess the Taylor and Sunstein idea of nudge, you know, the use of very small suggestions to members of the public to get them to behave in benevolent ways. Do we see that effectively as a form of freedom of thought, particularly when it may be, you know, Kate has suggested that transparency is one of the cures for dealing with improper interferences with thought. Nudge theory, as I understand it, by and large, wasn't about telling us why we're being told that it's a good idea to do a particular thing. It just is about trying to get people to move in a particular way. And what's your sense on that?
I think nudge. Yeah, I think nudge theory does raise questions, and the question will be, I suppose, in each example, which side of the line it falls, and I think it will come down to the specifics. But I think it is an area of concern, and that goes back to this question about absolute rights. That, you know, you can't justify, if it is an interference with the right to freedom of thought in the forum internum, then you can't justify it just because it will make us all better citizens. But I think it's also interesting when you look at, you know, the ideas of nudge theory. Again, if you look at it in a sort of political context about, for example, getting the vote out, you know, there's been research on very small shifts in the messaging, for example, with people suffering from anxiety, where a kind of get the vote out message, if it reminds you that going to vote is stressful, is actually likely to have the opposite effect in getting the vote out. And so I think there are questions around nudge technology that it's, you know, it's billed as something that will help us have better societies and behave as better citizens, but it can go both ways. And so I think there are big questions around nudge technology, and I think it certainly requires a bit more consideration.
Yes, I agree. And again, I think it's one of the things that needs to be unpacked. And in having this conversation, I think it's very important that we're engaging with psychologists as well, and also engaging with the advertising industry, who of course have been working with these kind of techniques for a long time, and so have that deep understanding of them. In addition to everything that Susie said, another question that occurs to me, is not one I can try to answer, is whether techniques that are appropriate, for example, in a commercial environment, ought also to be legitimate in, say, a political environment, because we have seen a sort of wholesale transfer of techniques built up by the advertising industry moving across to the political environment in particular, and are there issues there that ought to be unpacked too?
So another of our questioners has asked whether either of you would like to comment on more traditional types of violation of freedom of thought. For example, circumstances where you live in a totalitarian state where a whole range of speech, comment, activities are unlawful and very heavily punished, or in circumstances where particular religious groups or cultural or ethnic groups are subjected to internment or various forms of kind of isolation. I mean, do you see that as a freedom of thought, or is that really something that we should see more in kind of discrimination, freedom of expression breaches? At what stage does this become a freedom of thought issue?
Well, briefly, I mean, I think it is relevant for the right to freedom of thought. I mean, in those kind of cases, there's a sort of easier line to be drawn, if you like, and I think it also raises the indivisibility of human rights. So, you know, the right to freedom of thought is also relevant in sort of discrimination cases. And so if you look at, for example, the research that allegedly was able to assess whether or not, you know, what a person's sexual orientation was based on their photograph, so the sort of so-called virtual gaydar. You know, if you think about that supposed technology, regardless of whether it works, being used in countries where homosexuality is criminalized and even potentially with the death penalty, you know, you can see how these attempts for technology to supposedly get inside us and understand how we're thinking and feeling, you know, can be used against us and used in a discriminatory way. And so I suppose on the totalitarian regime, you know, you, as you've said, land up with whether it's religious groups or ethnic minorities or political groups being targeted, you know, arrested, murdered because of their thoughts and opinions as they're being expressed. If you then extrapolate that to the point where what they're thinking and their adherence to this group is based on an assessment of a brain scan or an assessment of facial recognition technology without them even ever actually expressing those thoughts, I think that's when you get an idea of why this forum internum protection is so important and such a sort of fundamental protection. And I think it's very interesting that, having reread 1984 a couple of weeks ago in the middle of lockdown and Zoom life, to just see Orwell's sort of descriptions of you know, what the thought police are looking for. So I remember there was one quote about, you know, taking an unusual route home wasn't illegal per se, but it was enough if the thought police noticed it to get you into trouble. And similarly, this idea that an act of rebellion was to write something down in a book and not to pass it through either the telescreen or the script write or speak write, I think it was, which was the word processing machine. So to actually write something aside from the surveillance becomes in itself a subversive act. And so I think the kind of totalitarian states that you're talking about, we see both the obvious and also we can begin to understand why that forum internum protection is so ultimately important as well.
Kate, anything you want to add there? So there's another question here, which is about the problem of tech addiction and how that might fit in with kind of freedom of thought. So we know that there are people who, you know, spend very, very large amounts of time on social media apps like Facebook or Twitter. And do we think that just kind of exposure, long-term exposure, impacts people's freedom of thought, or is that not really related to the problem of freedom of thought?
I think, shall I kick off on? I'm not sure about long-term exposure. I'm not sure I have anything to say on that. But what I would say is that I think that the desire we all feel to pick up our phones more and more, and I know that if my phone is within my vision, it's a distraction. I think that's a very good recognizable example of what we have been talking about in less recognizable forms, that the phone and things within it have been designed in such a way as to encourage me to want to pick it up as often as possible. And so that's a very good sort of easy example of what we've been talking about on a decent level. On the exposure side, I don't have any comments.
Yes,
Okay.
no, I would absolutely agree that the kind of question is design. It's not an accident that we're all looking at our phones if they're in the room, and you know, for children even more. And I think when you look at, you know, the way games are designed, they're designed using psychological tools that keep people going back for more. You know, so it's not the time exposure; it's the design that promotes time exposure. That I think is a question about freedom of thought. I think it's also interesting that there is increasingly research showing how the actual sort of formation of our brains and the way our brains work are impacted by our environments and sort of potentially by technology. So there's been research that seems to show that sort of using GPS, Google Maps is actually reducing our ability to navigate in the world and actually changing the form of our brains. So sort of reducing the hippocampus, which is enlarged in taxi drivers. So there's research that showed that London cab drivers doing the knowledge had an enlarged hippocampus, and the reverse is happening as a result of relying on technology to navigate. So I think there are questions as well about what, how technology is engaging with our brains and what it's actually doing to the way we think, which I think we haven't spent long enough looking at to understand, and which may have implications for freedom of thought, both now and in the future.
So a different question has focused on the the appropriate institutions for trying to develop the parameters, as it were, of freedom of thought. Given that I think both of you have emphasized that really the biggest challenge here is line drawing. What is the line, and where is the line between the forum internum and the external exercise of freedom of thought, which comes very close to expression? And how do we decide what is legitimate and illegitimate invasions of that internal forum internum? Which institutions are best placed to try to develop this? Is this a matter for courts, whether international or domestic? Is it a matter for legislatures? Is it a matter for drafting of kind of further and more specific international covenants? Is it a matter, perhaps, and we're seeing this increasingly, for the social media sector itself? Facebook, for example, has a very detailed code of conduct about what it is going to allow online and what it's not going to allow online. Is this something we should actually see the tech companies leading on? So what's your thinking about the institutional place for the development of the rules around freedom of thought?
Maybe if I start, I'm sure Kate's got some ideas as well, but I mean, I would say all of the above, really. I mean, I think the lines will be developed in part through advocacy and through academic research and sort of, looking across the piece, developing, ideas around it. But ultimately, I suppose business will respond, and potentially governments will respond, in response to what the public feeling is. And I think there is increasingly public concern about these things because it affects all of us. But they will also respond when the courts start saying, actually, you can't do that. So I think it's partly through the courts, but then courts also may feel more comfortable to come to certain conclusions when there's a body of research and discussion about what those things should be out there, rather than just making a judicial decision in a vacuum. So I think it's across the board. I think in some countries you have constitutional rights and systems where it's easier to start bringing cases than others. But I think there's also a need for an international framework, particularly because the tech companies are operating in an international world. And obviously I think at the moment, Europe is probably at the vanguard and the best region to start developing that. Although having said that, also in the inter-American system, there's quite interesting opportunities for developing ideological freedom in particular, and the inter-American system. But yeah, all of the above, I think.
Thank you.
Yes, I agree with Susie. I mean, again, going back to the comparison that Susie drew between thought, torture, and slavery, if you think about the extent of understanding of right to be free of slavery and freedom from torture and cruel, inhuman, and degrading treatment and punishment, we are here right at first base in terms of understanding this right. I think, therefore, that it would be premature to leap straight into, for example, an international drafting process. And as Susie says, at the moment, we need development by academics, development by the courts, development perhaps by governmental institutions, just as you have the Information Commissioner's Office on privacy and doing a lot of thinking about privacy. You could imagine a governmental institution, and there are governmental institutions, a centre we have one for data ethics and innovation, a similar kind of centre which could take forward thinking on this with a view then to legislating as appropriate in the future. We're too early to jump straight into the legislative phase. As Susie said, Europe's in the vanguard on this, and I think the Council of Europe has done some quite interesting work where it is picking up on this area. So that kind of international discussion is very valuable. And obviously it needs to get going very quickly because of the speed with which this technology is emerging and the threats to our technology, our democracy that we're seeing at the moment. As regards business, I'm sure that we will find a similar phenomenon to the freedom of expression issues, which is that social media platforms and other business end up having to decide where the parameters are in default of any other guidance. But as I said earlier, I don't think it's right or fair to leave those decisions to companies. It's not right because, of course, they always have their commercial interests, which they quite legitimately have to take into account, unlike public bodies who have a mandate to be considering the public interest. And it's also not fair because it's not what they are equipped to be doing either. Yeah.
Another question asks the question of how we think about waiver or consent by users of social media. So we know that in a sense, the idea that Kate put, which was transparency, was tell people that this is information coming from a certain place with potentially the intention of influencing your freedom of thought, that would help. But we do know that we are all very quick to consent to very many conditions that are imposed upon us contractually through the internet without ever even considering what those conditions are. And how do we think about, if we're trying to work out around legitimacy and illegitimacy, what's acceptable and not acceptable, where is the place for kind of consent by people to being influenced or manipulated in this way?
Shall I go first? I think that again is one of the very big questions, and I think there's a kind of question about whether you can actually consent to an interference with your forum internum. I think that is the fundamental question that I don't have a clearly defined answer to just yet. But I think that is debatable. You know, where you put that line. You know, just as you can't consent to becoming a slave, you know, can you actually consent to an interference with your forum internum? And that goes back to the question of defining what an interference with your forum internum actually is. So I think there are big questions about consent, but again, that there's really need to be developed around what you can and can't legitimately consent to.
I agree. First of all, I agree with Susie that there should be things that you can't consent to. We can't just sign it all away by clicking a button. But the second thing that I feel very strongly, and this really comes from work on the privacy side as well, is that consent has to be real. And at the moment, we all click away our consent to cookies as the price of, say, watching a video we want to watch or looking at a website we want to see. And that consent isn't real at all. And we have no idea, really, what we are giving away by doing that. And there's no reason, it seems to me, as far as I'm aware, why it couldn't be much, much easier for us to know what we're actually consenting to. So, for example, if we consent to a cookie that says your data will be shared with partners, well, it should be possible to click a button that shows us exactly what data is being shared and with which partners. And that ought to be available instantly, just at the touch of a button. And so the same then, if we're talking about consent, ought to be true in the freedom of thought context or any context when we talk about consent, that it ought to be very easily clear what exactly it is. And then you can actually make that calculation as to whether accepting what's on offer is worth it or not. The other point I would make is that I think terms of service are really important, and perhaps is something that haven't been thought about enough, whether in thinking of freedom of thought or in privacy and so on. Actually, again, it's part of what we are consenting to and the clarity with which that is presented to us and making sure that where there are terms of service by, for example, social media platforms or websites or companies that we engage with online, that those terms of service are actually reasonable in such a way as would meet, for example, Unfair Contract Terms Act in the UK. So that's another area, I think, which ties in with this consent question.
Well, I think we're coming to the end of our time, and I would like to thank both of you for really interesting contributions on freedom of thought. It's clearly an area we're going to be talking about more and more in the months and years ahead. I'd like to thank all of those people who've participated today, and for all of your questions. I'm sorry I haven't quite got to the end of the list, but they were really interesting questions. We're very grateful to all of you for putting them and for bearing with us through this presentation and doing it in this particular way. Certainly means that we can accommodate a lot more people in the room, so to speak. To ask all of you just to keep an eye on the Bonavero Institute website for our future webinars. We have had regular webinars on Tuesdays and Wednesdays over the last few weeks. We have another one scheduled for next Tuesday, so please keep an eye on that. And for the rest, just to say thanks once again to Susie and Kate for a really interesting discussion and presentation on freedom of thought, and to wish all of you well and to keep safe and healthy in these difficult times. Thank you very much indeed. Bye.